Hello everybody, Andrew Reed here, and we're going to do part 4 of the study guide for the NCA exams coming up in 2023, this one being the constitutional law, and we're just following along with the syllabus. This is part 4 of this study guide, which follows along with the trade and commerce portion of the syllabus. So let's go ahead and get started. So the NCA examiners start with the specific legislative authority of the Parliament of Canada is referenced in here. So we're looking at public debt and property here in section 91, regulation of trade and commerce, unemployment insurance, raising of money, taxing, borrowing of money on public credit, postal service, census and statistics, militia, army, defense, fixing of salaries for civil officers, beacons, buoys, lighthouses, navigation and shipping, marine hospitals, seacoast and fisheries, ferries between provinces and between territories, currency, banking, savings banks, weights and measures, bills of exchange, promissory notes, currency basically, interest, legal tender, bankruptcy, patents, copyrights, Indians, lands reserved for Indians, that's their wording, naturalization and aliens, marriage and divorce, criminal law, and procedure, prisons, and so interesting to note there is a lot of overlap, but in this case the federal government will have paramountcy in cases of overlap. The case that they reference here that's new to us, at least in the syllabus, will be General Motors of Canada versus City National Leasing. So this case was just basically an argument over special interest rates on leasing directly, but this court was faced with the issues as to whether an act that was related to this was intra vires under Section 91 and whether the subsection 31.1 was within Parliament's legislative competence. And the conclusion here in this case was this appeal should be dismissed. Both constitutional questions should be answered in the affirmative. So, yes, they were intra vires. Yeah. So, Rule 1 is quoted for what steps to use to determine whether something falls under the trade and commerce power. And this is the important takeaway from this case. 1. The impugned legislation must be part of a general regulatory scheme. 2. That scheme must be monitored by the continuing oversight of a regulatory agency. 3. The legislation must be concerned with trade as a whole rather than with a particular industry. The legislation should be of a nature that the provinces jointly or severally would be constitutionally incapable of enacting. And 5. The failure to include one or more provinces or localities in a legislative scheme would jeopardize the successful operation of the scheme in other parts of the country. So it doesn't have to be all of these. It could be some of them in part, but these are the general things that they're looking for as to whether it's valid trade and commerce power. So you can see that's relatively limited. The analysis of the court in this case is fairly lengthy, but it does break down how they are looking at those particular factors. First, court must determine whether the impugned provision can be viewed as intruding on provincial powers, and if so, to what extent. Second, the court must establish whether the act, or part of it, in which the impugned provision is found, is valid. In cases under the second branch of 91.2, this will normally involve finding the presence of a regulatory scheme, and then finding out whether the hallmarks articulated by the court, like in the rule, have been met by the scheme. If the scheme is not valid, end of the inquiry. If the regulatory scheme is declared valid, then the court has to determine whether the provision is sufficiently integrated with the scheme so that it can be upheld by virtue of that relationship. This requires considering the seriousness of the encroachment on provincial powers, because it is okay for them to overlap, double aspect doctrine. In order to decide on the proper standard for such relationship, so if the provision passes this integration test, then it is intra vires as an exercise of the general trade and commerce power. If the provision is not sufficiently integrated into the scheme, it cannot be sustained. In certain cases, some of these steps can be skipped over if a clear answer to one of them just resolves the issue. So this act in this case, in the General Motors case, is geared to eliminating activities that reduce competition in the marketplace and embodies a complex, well-integrated scheme of economic regulation to achieve that end. It identifies and defines anti-competitive conduct, establishes investigatory mechanism, provides a range of criminal and administrative redress to any infractions. So this act is concerned with the regulation of trade in general, rather than with the regulation of a particular industry of commodity. So check to that hallmark. The regulatory scheme is subject to the oversight exercised by the director and the commission. And the act is of national scope, aimed at the economy as a single integrated national unit rather than as a collection of separate local enterprises. Check to that hallmark. Then, the provinces jointly or severally would be constitutionally incapable of passing this legislation. Check. Finally, the failure to include one or more provinces or localities would jeopardize successful operation of the legislation in other parts of the country. So it has to be federal, is what they're saying here, so check to that. The regulations of competition falls within federal jurisdiction in its interprovincial dimension, and the act therefore need not to be read down, so that 31.1, the subsection in there, only applied to interprovincial trade. Because the regulation of competition is so clearly of national interest, because competition cannot be successfully regulated by federal legislation restricted to interprovincial trade, the validity of the federal legislation must be determined without heed to the provincial legislation, so said the court here. Competition, however, is not a single matter, and the provinces may deal with it in the exercise of their legislative powers in fields like consumer protection, labor relations, and marketing. So the court found the overlapping to be okay here. Finally, a second analysis on the individual Section 31, which created a civil right of action, which basically means an action of what to do if a contract is breached. Since the creation of civil action lies within provincial jurisdiction under Section 9213, which is the Civil Rights and Property of the Constitution Act, it appears to encroach to some extent on that important provincial power. However, the court found this encroachment to not be serious. Section 31.1 is only a remedial provision, and so those are considered less intrusive. They does not create a general cause of action, but it's a limited action. And finally, the federal government is not precluded constitutionally from creating rights of civil action when these measures may be warranted. So there's nothing that specifically says they can't do it. The inclusion of a private right of action in a federal enactment is not constitutionally fatal. Section 31.1 intrudes on the provincial power, but it's sufficiently related to a valid legislative scheme, and therefore, because of that relationship, it gets the constitutional validity conferred upon it. The provision is functionally related to the general objective of the legislation and to the structure and the content of the scheme. So it's all tied in together. As one of an arsenal of remedies created by the Act, it serves to reinforce other sanctions of the Act and takes on meaning only by reference to those other sections. The section provides a private remedy only for particular violations, does not create a private right of action at large. And the intimate tie between the purposes of the Act and a privately initiated and privately conducted enforcement mechanism is a strong indication that 31.1 is enmeshed in the fabric of the Act, to quote them. So, again, you can see that the court is really in favor here and sees this as being part of the trade and commerce power. Some notes in here. In Canadian National Transportation, this is from the detailed text of the case. I just want to pull this out here. So the judge had suggested that Parsons had established three important propositions with regard to the federal trade and commerce power. One, it does not correspond to the literal meaning of the words regulation of trade and commerce. It includes not only arrangements with regard to international and interprovincial trade, but it may include general regulation of trade affecting the whole country. It does not extend to regulating the contracts of a particular business or trade. So this was a judge in Canadian National trying to narrow down the definition of what trade and commerce meant, and those are 3 points as to how he determined that would happen. Now, in the syllabus, this goes on to reference the INRI securities, the securities reference case, which is covered in Part 3 in its entirety. So if you want to go back to Part 3, I'll put a link up on on the screen right now. There's a link right there in reference securities. Go back and watch part 3, and you can see the breakdown of that case brief. Best of luck on your NCA exams. Please, if you got value out of this video, smash that like button, comment, subscribe.